Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In today's video, we will discuss an extremely important and updated topic, unpacking exhibit rules under the Bharatiya Sakshya Adhiniyam, 2023, in family asset disputes. The Indian Evidence Act, 1872 has been repealed and replaced by the Bharatiya Sakshya Adhiniyam, 2023, BSA, which came into force on 1 July 2024. This new law modernizes how evidence, documents, and digital records are handled in Indian courts. If you are involved in a family property dispute, inheritance conflict, or asset division case, understanding these new exhibit rules under BSA is crucial. Let us explore them in detail. 1. Why the change from the Indian Evidence Act to BSA? The Bharatiya Sakshya Adhiniyam, 2023, was enacted to update India's law of evidence in line with modern realities. The 1872 law was more than 150 years old and contained many outdated colonial-era references. While the fundamental principles, like relevance, burden of proof, and rules of documentary and oral evidence, remain the same, the BSA introduces clear, simplified, and technology-friendly procedures. It especially strengthens the legal status of electronic and digital evidence, which is now a central feature in property and family disputes involving scanned documents, WhatsApp messages, emails, or bank statements. 2. Key definitions and expanded scope. The BSA broadens the concept of documents and evidence. Under this new law, a document includes not only paper records but also electronic and digital records, for example, data stored in computers, servers, memory devices, or communication systems. Similarly, evidence now includes statements given through electronic means, such as video conferencing, in addition to oral testimony. This means that under BSA, many electronic records, like a scanned property deed stored in your email or a digital gift deed, can be treated as valid evidence. These definitions give much wider scope to what can be produced and proved in court as an exhibit. 3. Step-by-step, how exhibit rules work under BSA. A. At the pleading stage. When filing a plaint or written statement, every party must list all the documents and digital records they intend to rely upon. It is now even more important to mention all electronic evidence, such as digital deeds, bank records, or screenshots, right at the beginning. If you omit any key record, producing it later becomes difficult unless the court grants special permission. B. During evidence stage. At the evidence stage, the party or witness who can prove the document produces it before the court. The document is then marked as Exhibit P1, P2, etc. for the plaintiff, or Exhibit D1, D2, etc. for the defendant. Under BSA, even digital or scanned documents can be primary evidence if they are produced from proper custody and their authenticity is not in question. The court examines the document and admits it as an exhibit only after it is duly verified. If there is a dispute, the court will first decide on admissibility before treating it as evidence. C. Objections and cross-examination. The opposing side can challenge the authenticity, authorship, or execution of the document, or claim that it was tampered with. Especially for digital records, you must be prepared to prove their chain of custody, how they were created, stored, and secured, and that they were not altered. This can be established through metadata, server logs, or expert testimony. 4. Important provisions under BSA on documentary and digital evidence. Let's now look at the key exhibit-related provisions under the Bharatiya Sakshya Adhiniyam that directly affect property and family asset cases. Section 57 of the BSA defines primary evidence, which now includes electronic records. If you produce a digital file from its proper source, it can be treated as primary evidence without needing the complex certification earlier required under Section 65B of the old Act. For instance, a scanned copy of a registered sale deed stored in your email can qualify as primary evidence if its origin and integrity are proven. Section 58 deals with secondary evidence, broadening its scope to include oral admissions, expert reports, and verified copies. So if an original property document is lost, you may still prove your case with credible secondary evidence like certified copies or expert testimony verifying the document. Sections 61 to 63 provide special rules for electronic or digital records, clearly laying down how they should be produced and verified. Section 66 recognizes electronic signatures and explains how they can be proved, which is extremely relevant when dealing with digitally signed family settlements or gift deeds. Section 67 explains the proof of execution of attested documents such as wills and gift deeds, incorporating modern methods of verification. Finally, the Act introduces new presumptions regarding the authenticity of electronic records and digital signatures, which means that courts may presume the genuineness of such records if they meet certain technical and procedural standards. All these provisions together make digital evidence as strong as physical documents, provided they are properly preserved and produced. 5. Burden of proof and admissibility. Sections 104 to 107 of the BSA deal with burden of proof, meaning who must prove what. In family disputes, the person asserting ownership or execution of a document must prove its authenticity. For example, if a party claims that a will or settlement deed is genuine, that party must lead evidence of its execution and attestation. Admissibility depends on several factors. The document must be relevant, duly stamped and registered, where required, produced from proper custody, and authenticated if electronic. Only when these conditions are met can it be accepted as a valid exhibit. 6. Practical guidance for lawyers and litigants. Under the BSA, preparation is everything. First, make a comprehensive list of all property-related documents and digital records, such as title deeds, bank records, and family settlement communications, and include them at the time of filing. Second, maintain a clear chain of custody for digital evidence. Keep copies of emails, storage logs, and timestamps intact. Third, if any document bears a digital or electronic signature, collect the necessary verification data, as Section 66 of BSA provides a specific framework to prove such signatures. Fourth, have all documents translated and certified if they are in a regional language, as the court will rely only on verified versions. Lastly, during arguments, always refer to each exhibit by its number, like Exhibit P3 or Exhibit D1, for clarity and accuracy in presentation. 7. Common mistakes to avoid. Despite the clarity of the new law, many litigants still make serious mistakes. They often rely on unregistered family arrangements that carry no legal weight or submit photocopies instead of certified or original records. Many also forget to maintain digital authenticity, leading to doubts about tampering. Failing to prove an electronic signature or not producing proof of how a document was executed can result in rejection of that exhibit. To avoid such pitfalls, always verify every document's admissibility under the BSA before filing it. 8. Example, a realistic illustration. Consider a situation where two brothers are disputing ownership of ancestral property. One brother claims that their late father executed a digital gift deed in his favor, signed electronically and shared via email. The other brother denies this and alleges forgery. Under the old Indian Evidence Act, proving this digital deed would have been extremely difficult, requiring a 65B certificate and multiple layers of proof. However, under the Bharatiya Sakshya Adhiniyam, that same digital deed is recognized as a document, and if produced from proper custody with evidence of an authentic electronic signature, it is treated as primary evidence. The brother relying on it must show who created it, how it was stored, and confirm that it was not tampered with. The court will then mark it as an exhibit, say Exhibit P1, and allow cross-examination. This updated law thus gives much stronger recognition to digital and electronic evidence in family asset cases. 9. Final takeaway. The Bharatiya Sakshya Adhiniyam, 2023, represents a modern and forward-looking approach to handling evidence. It recognizes that today, much of our communication and documentation happens digitally. For those dealing with family property disputes, it is now easier and legally safer to rely on digital records, provided they are genuine, verified, and properly presented. Therefore, always ensure that your exhibits, whether physical or electronic, are prepared in accordance with BSA. Properly admitted exhibits form the foundation of a strong case and often decide its outcome. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.